He doesn't raise his voice. He doesn't need to. Senator Sheldon Whitehouse walks into that committee room with a list, and every item on it is a door the Justice Department slammed in his face. Ask a question, get insults instead of answers. Ask for documents, get silence. File a formal records request, watch it vanish.
When we ask questions, we get scripted litanies of insult and quarrel rather than actual answers to our questions. When we ask for documents and records in writing, we get nothing. We are reduced to filing FOIA requests that are then not even complied with as FOIA requests. So the oversight function of this committee is really, I think, being systematically disabled.
And now, he says, the committee is about to do something worse than fail. It's about to bury the whole investigation by folding its oversight of the Department of Justice into the confirmation hearing of the very man accused of running it into the ground.
That's particularly significant when you have Attorney General Bondi saying that it was Todd Blanche who was responsible for the Epstein files disaster.
The Epstein files, a so-called slush fund tangled up with a tax deal for the Trump family, and a charge so rare, Whitehouse says he's never seen it in his career. 36 retired federal judges, including conservatives, accusing senior DOJ officials of committing fraud upon a court. The deadline is Friday. The department's answer so far? They ducked. Let's get into it.
I'd like to take my time this morning to suggest that combining our oversight hearing of the Department of Justice with the nominations hearing for Acting Attorney General Blanche would be a grave mistake for the committee. I don't believe we did that with Attorney General Garland, and I think the record of the Department of Justice under Todd Blanche lends itself to very vigorous oversight. Oversight which we have been denied because when we ask questions, we get scripted litanies of insult and quarrel rather than actual answers to our questions. When we ask for documents and records in writing, we get nothing. We are reduced to filing FOIA requests that are then not even complied with as FOIA requests. So the oversight function of this committee is really, I think, being systematically disabled. That's particularly significant when you have Attorney General Bondi saying that it was Todd Blanche who was responsible for the Epstein files disaster, the releases of private information and images of victims, the cover-up of documents that named Donald Trump, and just the general incompetence of the whole wretched mess. I don't think that it would be a good idea for this committee to be complicit in covering up the cover-up of the Epstein files. Move on to the slush fund, which a great number of my Republican colleagues have expressed real reservations about, with its attachment of a tax amnesty deal for Trump, the Trump family, and the Trump businesses. There are very legitimate questions to be asked about that, including, has that cockamamie idea really been withdrawn, or is it just being hidden briefly so it can resurface in some other fashion? We should be looking into this as a committee. It's important stuff. And even if we shirk our duties at looking into all of this, it appears that a Florida court is going to be looking into all of this. And I think it's a bad look for the committee to be turning a blind eye to what went into the slush fund deal and the tax amnesty deal, and then discover through a court proceeding in Florida all the stuff that we failed to look at. It's hard to be taken seriously if we have failed to do our own duty, and then the court proceedings reveal the mischief. I will say that I've looked. I have never, ever heard of senior officials of the Department of Justice being called before a court with respect to a fraud upon the court. Look up fraud upon a court. It's a pretty serious charge. This one was raised, I guess I should say, by 3 dozen retired federal judges, some very, very respected ones, some very, very conservative ones. And the judge in the proceeding in Florida, out of which the slush fund settlement emerged, reopened the case to have a look. She asked for responses. She suggested that the DOJ might have violated its own policies in this settlement. She suggested that there was an IRS defense memo out there that would be relevant to the proceedings. The violation of DOJ policies would obviously be a matter for DOJ to answer. The IRS client memo would obviously be something for DOJ to answer. She also questioned whether there was collusion. It takes two to collude. It would be a collusion between the Department of Justice lawyers and Trump's private lawyers. So there's another reason for the Department of Justice to have responded. What happened last Friday? No response from the Department of Justice. First ever accusation of senior level Department of Justice people of fraud upon the court with an invitation to rebut the allegations, an invitation specific to Department of Justice conduct, and they duck. So that is going to continue. The 3 dozen judges have their answer this Friday, and then the court will go forward. I will contend that we don't look like much if that information is being developed in a federal courtroom and we haven't been allowed to ask questions, and indeed our oversight has been collapsed into a confirmation hearing. I have never seen a Department of Justice as badly run as this one. I've never seen fraud upon the court allegations. I've never seen so many suggestions of contempt. I've never seen so many no true bills. I've never seen so many cases thrown out. I've never seen so many accusations that department arguments were false, were pretextual, were designed to fool rather than inform the court. And we see that over and over again from judges appointed by every president. It is now at the point where the Department of Justice and the U.S. government have lost their presumption of regularity in federal court proceedings. All of this matters. All of this is something to which this committee should be paying attention. And with respect to what our chairman has said about the norms of the committee, well, one norm is that U.S. attorneys come through this committee after a process of consultation before they get to run U.S. Attorney's office. Over and over again, we see these slippery deals where acting U.S. attorneys are appointed, and then the first assistant is fired, and when the time runs out on the acting U.S. attorney, they slip back into the first attorney position and leave a vacancy. It's an obvious scam to get around this committee's norms. And we have put up with this. It didn't happen once, it didn't happen twice, it has happened over and over and over and over again. And on top of that, we've seen U.S. attorneys called out for misconduct over and over and over again. None of this is normal. None of this is normal. And the fact that this committee won't look into it, I think, is a shame. And I think if we try to be complicit in failing in our duty to look into this by combining the Blanche nomination hearing with the Department of Justice oversight hearing, we will have made a very, very grave mistake. Thank you, Chairman.
What makes this statement land is that Whitehouse never has to perform outrage, because the structure of his argument does the work for him, and that structure is a procedural trap he is warning the room not to walk into. His entire opening objection is about a scheduling decision that sounds boring until you understand what it hides: the proposal to fold the committee's oversight of the Department of Justice into the confirmation hearing for the man who runs it, Todd Blanche. Whitehouse argues that this is not housekeeping but a way to smother scrutiny, because a confirmation hearing is built to evaluate one nominee, not to interrogate an entire department's conduct, and merging the two means the hard questions simply never get asked. He sharpens the point by noting they did not do this with Attorney General Garland, establishing that what is being proposed is a break from how the committee has operated. And then he builds his case that oversight has already been quietly strangled. When senators ask questions, he says, they get scripted litanies of insult instead of answers. When they ask for documents, they get nothing, and even formal Freedom of Information requests go unanswered, which is his way of saying the normal tools of congressional supervision have all been disabled one by one. From there, he moves to the substance of why that oversight matters so urgently, and the first pillar is the Epstein files. The detail he leans on is politically explosive, that Attorney General Bondi herself reportedly pointed at Todd Blanche as the person responsible for what Whitehouse calls the Epstein files disaster, a phrase that covers the release of private information and images of victims, the alleged cover-up of documents that named Donald Trump, and what he describes as general incompetence. The line he chooses to crystallize it, that the committee should not become complicit in covering up the cover-up of the Epstein files, is designed to put every member on notice that inaction is itself a choice with consequences. He then pivots to a second pillar, what he calls the slush fund, a settlement bundled together with a tax amnesty deal benefiting Trump, his family, and his businesses. And he is careful to note that even Republican colleagues have voiced reservations, framing this as a matter of institutional duty rather than partisan attack. His question of whether that idea was truly withdrawn or merely hidden to resurface later is the kind of suspicion that keeps an investigation alive, and his warning is blunt, that a Florida court is already digging into this, and the committee will look foolish if a courtroom uncovers what the senators were too timid to examine themselves. The heart of the statement is the legal charge he keeps circling back to, fraud upon the court, and Whitehouse treats it with the gravity of someone who knows exactly how rare it is. He tells the room he has never heard of senior Justice Department officials being hauled before a court on such an accusation, and that this one was raised not by activists, but by 36 retired federal judges, including some he calls very respected and very conservative, which strips the matter of any partisan coloring. The judge overseeing the Florida proceeding reopened the case, asked for responses, and floated several serious possibilities that the DOJ may have violated its own policies, that a relevant IRS memo exists, and most strikingly, that there may have been collusion. Whitehouse pauses on that word with a simple observation, that it takes two to collude, and the two parties here would be Department of Justice lawyers and Trump's private lawyers, which would mean the government's own attorneys working hand in glove with the president's personal legal team. Then comes the moment that turns suspicion into indictment. His account that when the deadline arrived last Friday, with a formal invitation to rebut these allegations, the Department of Justice simply did not respond. In his telling, an innocent department answers, and a department that ducks an invitation to clear its name is telling you something. He closes by widening the lens from one settlement to a pattern of institutional decay, reciting a litany he says he has never witnessed in his career: fraud upon the court allegations, suggestions of contempt, grand juries returning no true bills, cases thrown out, and accusations from judges appointed by presidents of both parties that the department's arguments were false, pretextual, and designed to fool rather than inform the court. The phrase he uses to summarize the damage is the most consequential one in the speech: that the Department of Justice has lost its presumption of regularity, The basic trust courts normally extend to the government that it is acting in good faith, and once that is gone, every argument the department makes starts from a position of doubt. He ties it back to the committee's own norms, describing what he calls an obvious scam in which acting U.S. attorneys are installed, first assistants are fired, and officials shuffle positions to dodge the Senate consultation process that is supposed to vet them. His final warning is the same as his first, that collapsing oversight into a confirmation hearing would make the committee complicit in its own blindness. A grave mistake delivered not as a threat, but as a quiet prediction of how history will judge a body that chose not to look.